Oh, 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 oh. Everybody say, ah, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, yeah, enough to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. See, I call you Zion. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya matinyana. Hello, hello, lovely people. It's another wonderful Saturday afternoon, the very last one in the month of March 2023. We're here to bring you the community and the law. I look through my window and I see it's so golden and sunny out here in London, and I believe it's so lovely wherever you find yourself. My name is Recourse, and the question I'm asking is, how do I qualify for benefit if I have no recourse to public fund on my resident permit? And that condition, what is it? How do we get rid of that? What is public fund? We'll be defining all that. And listen, we're doing that by courtesy the one and trusted community partners when it comes to the law, BWF Solicitors. Ladies and gentlemen, we're live on BW TV, we're live on BW Radio, we're live on BWF Solicitors Facebook page, we're live on BWF Solicitors YouTube page, and all these social media platforms. So call one, call two, call three, call everybody to come around that the community and the law is airborne, and we'll be right into it together. Okay, lovely people. Thank you very much. And I believe that you're all doing so very well. It's the last Saturday of the month of March 2023. We're moving and soldiering on for God, country, and survival. We're doing everything for our own mutual good. And today I have loads of goodies on the program for you. So I wouldn't want you to miss it. Not for all the gold in the world. I would want you to come on board and join us as we as a community discuss the legal side of things. Once again, my name is Ureku Fripon. Thank you very much for joining us. We're here in the next 120 minutes to discuss something so pertinent to our stay here in the UK, and also to make sure that we do things right. Tonight, we are looking at the question, how do I qualify for benefit if I have no recourse to public fund condition on my a resident permit. Lawyer Charles Asma, my usual and resident guest, will be here, and we'll do that courtesy BWF Solicitors. I just want to remind you that we're live on BW TV, live on BW Radio, also live on BWF Solicitors social media platforms, talking YouTube, Facebook, LinkedIn, and all the other bits. And what we do as we start our discussion and, of course, our deliberations, I ask you all to pick up the link, share it in your network. So let's go to do that. And I want to say thank you to BWF Solicitors for allowing us to come their way and also to answer questions. And they are so gracious to answer us. BWF Solicitors is at 214 to 218 on the Tottenham High Road, North London, N15 4NP. If we're going via public transport, the underground, so to speak, we join the Victoria line towards north, and we alight at Seven Sisters. Now, when you get off the train, look for exit number 2. Exit number 2 will take you to the frontage of the building known as the Anna House. BWF Solicitors is on the 4th floor, the very top floor. Go there. You can get them between Monday and Friday, 9:30 in the morning and 6 p.m. Monday, Tuesday, Wednesday, Thursday, Friday. We saw BWF Solicitors is so close to the Tesco on the Broadway, so it's not something you will miss at all. Call them anytime, 0208 493 7340, 0208 493 7340, or 077 127 61884, 077 127 61884. Now, today I'm just going to just vary my sequence just a bit. Before I go to say thank you to BWF Solicitors, let me introduce my friend, my brother, and my guests, my resource person, Lawyer Charles Asma from BWF Solicitors. Boss, good afternoon.
Good afternoon, brother.
We have gone through virtually the first quarter of the year, January, February, and March. And you have been so gracious to being regular as my resource person. One, thank you very much. And then once again, welcome to the show.
Thank you very much. First off, we are grateful to God for the opportunity to be alive and the opportunity to be a blessing to others.
Right.
And we also thankful to management of BWF Solicitors for this platform and for the opportunity to reach out to our wonderful viewers and listeners. And of course, gratitude is also worthy of mention of our many wonderful listeners and viewers. Today we have met again. Let's become a blessing to others. And thank you, Black Oku.
Well, thank you very much. You see, he mastered the art of making you so comfortable and welcome. That's the bit, and that's the beauty of being with BWF Solicitors. Now, having recognized your presence, all of you on the platform, and everybody that's joined us, let us say thank you to BWF Solicitors, and we'll be right back.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we'll get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, welcome back. Thank you very much. Now let's go on the platform and welcome people who have joined us. I have Kwame Tajima. Oh, this nice gentleman. I have not seen you in a long while. You're watching from Harlow. Thank you very much. I know wherever you went on your journeys, you have had a lot of benefit. Blessed afternoon to everyone, says Nanaya. Nanaya, thank you very much. Next, we have Mami Kunedi. Good afternoon, Obaya Papebi. And thank you very much, Mami Kunedi. Sandra Fraser, please share when you join. That's the deal. That's the real deal. Sandra, thank you very much. And the next one we here have Chi Wo. You are all welcome on board. You see me punching my screen. That's exactly what I'm going to ask everybody to do when you come on board. Pick up the link and share. Good evening, all. Margaret Dumensa is saying that. Next we have Margaret Aduensa again calling people to come in and join us. Then again, we have Nana Tufua, keep up the good work. Thank you very much, Nana Tufua. You also keep up the good work. And he has done it. He has spread the beans. Share, 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 share until the share is done. Okay, now, who else do we have? If you have other people, just ring them and say we are live on BWTV, live on BW Radio, live on BWF Solicitors on Facebook and YouTube and all the other platforms. Now, let me get some announcements out of the way. The Easter period is here with us, and Easter is going to be time for us to, as people who are Christians, to celebrate the resurrection of the Lord and Savior Jesus Christ, and also time for people to also have a break from work and reflect on the things we do. So BWF Solicitors, together with the ICGC King's Temple, is having an Easter clinic and barbecue for everybody. So you're all invited. Come join us at ICGC King's Temple, Frederick Bremer School, Siddeley Road, Walthamstow, East London, London E17 4E1. You're going to have a lot of food, a lot of things to drink, and of course, free legal consultation. And BWF Solicitors is representing live there. So please make a date, don't be late. The other thing too I want to draw your attention to is our colleague now, Mayeti, is around, and she's going to lead us into or give us an insight into what it is that she does every Sunday. But before then, if you want to prepare for your English language test, please consult KT Ed Consult, and they will help you to really do what it is that you have to do. I'm going to have my colleague now on the line on video. So we'll go to that scene that says host and the guest outside. Yes, we are going to have Na on there to help us with that. Shall we take just a short break and we'll be right back? Okay, so now let's go onto the line, as I said, and speak to Na Mayeti. Na, good afternoon.
Good afternoon, Reku. Good afternoon.
How are you doing?
God is faithful, my dear. I'm doing great. What about you?
The Lord has been so gracious unto us. And I mentioned to Lawyer Charles that we have gone through what, 3 months of the year. The first quarter is gone, and the Lord has seen us through. And He has also been very gracious to be representing every Saturday afternoon. But I am moving right one step into Sunday, and I know that you have a show which I would want to share with all my wonderful viewers. We're talking about the Mighty Show. Take us into it. What do you do on a Sunday afternoon?
Okay. Thank you, Reku. Magneti Show is actually a program purposely designed for the Ghana Adangbe Society in the diaspora. And it's not just limited to the GANs, because the some of the content that we have is things that trending in Ghana and the Gandangbe in Ghana in particular. So if you're Ghanaian and you can speak and understand the Ga, I can say you are part of the show. So we talk about the news, we talk about the culture, we talk about traditions, we talk about lifestyle, we talk about basically everything concerning us. Just that we speak mostly the Ga language. So if you watch me on Sundays, you hear me speaking Toyote, Tachobute, Ufane, Umanyaba, and stuff like that.
And
So that is
for our dear viewers who do not understand those things, um, I know the first one is what's your name, how are you,
yes.
and all that. Can you take us through it again, just briefly?
Okay. Yeah, exactly.
So
So it
Teote is how are you?
Toyote is how are you? Yes.
Okay.
Tachobute, that's what's your name.
Hmm.
And Omanyaba, let the good news come. I mean, let's welcome the good news, something
Okay.
like that. So
So what times do you have to meet Sundays?
it's actually between 2 to 5, from 2 to 5. It's 3 hours solid program, and it's a talk show. So we invite people to contribute when we have the news headlines, whatever is trending out there. We have people to contribute their opinion, their contribution, their suggestions, and stuff like that. And we have some key people. When I say key people, we have some chiefs, kings, and most of the elders in Ghana and the leaders behind this program. So it's like a channel that they hear what is happening in the community, the concern of some people about basic issues. And when we channel the message to them, those that they can act on, they do. Those that they can't and it's out of their control, they just leave it to be. So that is what we are doing. And tomorrow, we do have guests. Also, sometimes we invite people, musicians, leaders, I mean, people with some sort of area specialization to come on board and then educate us as well. So tomorrow, for instance, we are going to have Augustine Yale, who is actually the marketing manager for the Diaspora Insurance. I know most of people know him around. He's coming to talk about whatever entails, I mean, from A to Z information that we need to know about the Diaspora Insurance. So yes, that's what some of the things we do.
Okay, so we'll have to make a date with you between 2 and 5 p.m. I just want to remind everybody that between midnight and 1 a.m., UK and Europe is going to go through into the best summertime. So GMT will be 2 o'clock,
Mhm.
um, and UK will
Ghana,
be 3. Ghana will be 2 o'clock or 1 o'clock.
no, Ghana will be 3 o'clock, and Ghana will be 1 o'clock, and UK will be
UK will
two.
be 2 o'clock. Okay, yeah. The other thing I want you to touch on before you take leave of us for this segment is the KT Ed Console, the IELTS that you support people to write. Can you quickly take us through that as well?
Yes, KT Ed Consult is one of the providers for the IELTS in UK. Main area of instruction is through the Zoom, so it's worldwide. It doesn't matter which country you are, you can still join us, and we can deliver the teaching aspect of the IELTS, teaching and learning aspect of the IELTS. Then we have some exams practices as well. And thank God, Katie, two of the experts in Katie happens to be, especially one of them happens to work with those what do you call it? Those providers for home office themselves, so we happens to see for hand some of the questions for the months, and then that is where we try to practice most of the time for our clients or our students. So we always have that kind of success because you happen to know what you are going to face, and that is what Katie is all about. You get to know exactly what you are going to see during the exam. So when you join us with Katie, you are bound for your success. It's not just only IELTS that we do also CELT. So with the IELTS and CELT, CELT is those ones we have in the UK, and the IELTS is those ones that we have from the UK, that's outside the UK. So it's not just that. Also, we have a recruitment attached to that, where we can also recruit people from Ghana to come and work, especially in the care sector. So if anyone also interested to come to the UK to work as a care worker, we've liaised with some of the companies that got the sponsor license, so we can just channel all your process your document for you, and then you can get you can be recruited to come and then work in the UK. And also we do have the teaching aspect as well. If you are a teacher in the diaspora, I mean, if you're a teacher back home, especially Ghana or Nigeria or elsewhere, and you are interested in coming to teach in the UK as well, there are guidelines, there are processes that you need to follow. And these guidelines and things, Katie can take you through all of them. We can liaison you with the school, and then we can organize the interview session. Whatever they'll be asking you during the interview, we can probe you. So when you are called to be interviewed, find out that you already prepare for them, and that is what the KT experts, that's what we do. And then you can get your school to come as well. And also recently, thank God, one Trinity College, being the main provider of salt in the UK, has liaisoned with Katie. So it's not just English that we are teaching, but very soon we've been licensed to teach NVQI level 2, level 3. So that's a good news for Katie. And those of you who want to specialize in the care training, maybe specialize in any NVQ subject, Katie is there to support you throughout. We can also deliver functional skills. So those of you want to go to university and they are demanding you have GCE level English and math, and you are struggling with it, Katie is here to support you to have those levels, to go and apply for university course. So that's all that Katie does and other things. So real cool, if you ask me, this is what I can say about Katie.
Well, thank you very much, and that's very handy, and we'll continue to promote so that people will know and get the best from the experts and pass once and for all. Thank you. Maybe we'll come back to you later on at the latter part of the program with questions for you to help us with. Thank you, Na.
Thank you, Rick.
Okay. Now Maya Ting is my co-presenter, and she has come to help us with that. So straight away, I'll go to our nuggets. So I bring in Lawyer Charles Asma to help us with that discussion. Now, this week, what was thrown into the community is about inheritance. Last week, we discussed writing a will and what goes into that. Now, today we're looking at inheritance. Who takes ownership of things that you have acquired and left behind. Inheritance, that is Provision for Family Independence Act of 1975, gives power to the court in certain circumstances to vary the terms of a will if it fails to make reasonable financial provision for a surviving spouse, child, or someone who has been maintained by the deceased during their life. A claimant will be expected at a very early stage to provide full disclosure as to their own financial needs and resources. A person is classified as being maintained by the deceased if they were financially supported by the deceased in some way during their lifetime and that maintenance continued until the death. This is quoted from Inheritance Provision for Family and Dependents Act of 1975. And it's a case that's quoted Elliot versus the Blue Cross and others of 2017. It's a UK Supreme Court case of 2017. Lawyer, that's somebody would say, I have a Nigerian friend that keeps saying that there's a lot of English. So
Yes.
take us through it, break it
All right.
down, and unpick it for us, please.
Thank you very much, viewers and listeners. We are looking at limited right of people who may not have been mentioned in the will of the deceased. So we are aware from previous discussions that when one makes express wish for people regarding how his or her estate should be shared, we say the person has made a will. And once the person has made a will, we have to follow through what they have specified. What if the person has made a will, but somebody might not have been mentioned in the will?
Right.
And everything indicates that the person was dependent upon that deceased family member, and that dependency or support is expected to continue after death.
Okay.
What do we do? Because the will has stipulated how the properties or estate will be shared.
Right.
So how do we cater for the need of the person who is left out? And yet there is expectation that the maintenance they were receiving will continue after death.
Okay.
So here we have to rely on the provision within the Inheritance Provision for Family Independence Act 1975, which gives the court power in some. So here it says in certain circumstances. So not all the time. And therefore the fact will be very important. So the court will look at the circumstance of this particular instance or the case and say that in this on this occasion, we have to do this because we have the power to do that. And what has the power required them to do? The power required them to vary the terms of the will.
Okay.
So more or less, that even though the person, you see, the first of the will is the intention, express intention of the dead person.
Okay.
And after death, you cannot touch the will anyhow. But the law gives the court the power to change the desire of the dead person somehow. Therefore, if the dead person has not been fair in their will, the court has the power in some circumstances to vary the terms of the will. And what would the court do? The court would then bring in the need or needs of those people that the deceased person was maintaining or looking after.
Okay.
And whose needs ought to be continued. And they were left out of the will.
One would ask that if the person so knew that I'm catering for these people, I was maintaining them, but in my will, which is my desire and my wish to be carried out after I'm dead, was that I don't continue to support them, why would the court vary such?
So it says if the person fails.
Okay.
So there is a condition. And the condition is that the person should have failed to make reasonable financial provision for those people.
Okay.
Either because of acrimony or misunderstanding between them, the person said, you know, I was planning to include you, but I'm no longer going to include you. Those things are bound to happen. So where the person fails to make provisions financially in the will, especially for the needs of the surviving spouse, the child, and someone who has been maintained by the person, and could be so someone who has been maintained by the person could be a third party, someone who is not a family member, but this person is the one helping them through education, through essential living needs. and they are gone, then we expect them to have been catered for, such need to have been catered for in the will. So if it is not done, then the court has the power to change, not to change, to vary the will to
Okay.
accommodate those people. So who are the people we are covering? The court power covers those people such as spouse,
Okay.
surviving spouse. So if the surviving spouse is left out, remember under intestacy, the surviving spouse needs are catered for by the operation
The
of the
operation of the
intestacy law.
law. Right.
But if the person has made their will and has left the spouse out, then nobody can change it. But the court
Court can vary
has the
parts.
power to vary that if the person fails to make financial provision to cater for the needs of the surviving spouse and also children and anybody else the person was maintaining before death. And therefore, we expect that maintenance to continue. So these are the categories of people. And if somebody, why would the person leave the children out? But it's possible. So if the person left the children out, so and here you can see that it does not qualify the child. It says surviving spouse, a child, or someone else. So if the person is a child, regardless of whatever happened between the dead person and that child, it doesn't really matter.
Okay.
If the person is a child, then the court has the power to vary the will to cater for their need if they are in financial needs.
There's a very interesting scenario here. This for the purposes of our discussion, but is a live case, and I believe that the family would agree with me. For instance, the very popular Ghanaian footballer that passed on, he died in the earthquake in Turkey. He has a foundation in Ghana that caters for needy. In fact, it's a care home or orphanage. Now, if for purposes of our discussion, if he didn't leave anything in his will for such support to continue, can anybody, like any member of the family or close to the law, advise the court to vary something for something to be done for this orphanage? Because without him, they may not survive, or the orphanage may even close.
Well, that would be something that somebody would wish to do to test the law, but there's no provision as such. And mind you, it's a jurisdictional matter. You made reference to a particular jurisdiction.
Right.
The discussion currently we are having looks at inheritance provision for the needs of family members, and we're looking at the 1975 Act. And this is a UK provision.
Okay.
There will be a similar provision in Ghana and elsewhere. And therefore, we have to check what that entails, whether
In that
that
jurisdiction.
provision may have similar provision arrangement. If there's similar provision in place, then their needs are likely to be catered for that foundation. However, if the person left a will and did not include those people.
Ones. Okay.
So the next question we want to ask is, in this scenario or the fact pattern we have to check whether there is will involved. If there's no will, then this does not cover.
Okay. All right. Then finally, if the court makes a variation like that, can anybody contest it?
So you see, the court has the power to.
Okay.
So the court would assert its powers or right over the will of the deceased person. And the question is whether you are taking the court to court. I'm not sure how you're going to fight it off.
Taking the court to court. Okay, that's very interesting.
So it's not a choice.
Okay.
It's a provision or operation of law. So somebody who feels that the deceased should have considered their needs to include them in the will can rely on this provision to request the court to apply or to make use of the powers it has within the law.
Okay.
Can somebody also tell the court not to use the powers it has within the law? There's no law saying that you can challenge the court's use of its powers.
Okay.
Because if the court does not do that, then more or less they are not following the law.
Okay. Yeah.
Yeah. So unfortunately, there isn't contemplation for those people who may bring or may contest such a bit. So I'm sure everybody would want to, if the court is doing something, they don't want to, as long as, and the court knows how to do it in a way not to jeopardize not to disadvantage those people who have been mentioned in the will.
Okay. All right. Well, thank you very much. I will pick up the very last announcement and we go into our topic for discussion today. If you just joined us, you live on BWTV, and my guest, Lawyer Charles Asma from BWF Solicitors, is going to help us look at the thing called no recourse to public funds. And the question I'm asking is, how do I qualify for benefit if I have no recourse to public funds on my resident permit as a condition? We will be looking in detail about that. But on the 31st of March 2023, the Miss Ghana Foundation has an event they are going to host. And they have really launched a campaign that says Pound for a Pad campaign. Now, Pound for a Pad campaign is looking for resources and money, so to speak, to buy sanitary pads for young women in deprived areas, especially some parts of Ghana. And what they are doing now is to ask all of us to come dine and donate. It's a meetup for support for the campaign. So what they're saying is they want us to connect over food and drinks to learn more about the Pound for a Pad campaign. And they also will provide you with opportunities to network with like-minded individuals and also donate to the good cause. It's happening on Friday, the 31st of March, 2023 at 7 p.m. It's happening at Blooming Scent Cafe, 639 High Road, London, N17, 8AA. And remember, BWTV and BWF Solicitors are proud to be associated with this event. So remember, on the 31st of March 2023, 7 p.m., we're all meeting at Blooming Scent Cafe, 639 High Road, London, N17 8AA, to support the Miss Ghana UK Foundation to raise money and support for the Pound for a Pad campaign. So please make a date and let's all meet there. We take a short break quickly and we come back straight into our discussion.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome back, and thank you for your time. I wanted to actually bring on the Miss Ghana UK Foundation board members. Well, when we get through to them, we'll see. Um, do we have them on board now? No, I don't think we do now. So I'll go straight into the discussion. I've been having indication that they wanted to call in, so we'll see. But Laura, let me look at this. I don't want to call it a monster, but I will call it something that scares people. Somebody is giving the permission to live in the UK, but on the the permit, it is written no recourse to public funds. Um, Let me quickly get this out of the way. I know we were waiting for them, but let me bring them on. I have Sila Jill of the Miss Ghana UK Foundation with me. Sila, good afternoon.
Hi, good afternoon, Kweku.
Thank you for
How are you
joining.
today?
I'm very well, thank you. How are you?
Not too bad, thank you.
Good. I was just going on about Miss Ghana UK Foundation, your campaign that is a pound for a pad. What is that
Yeah.
about? If you could reiterate that for us, please.
So, a pound for a pad is basically about menstrual poverty. As we all know, when it comes to a female, basically our menstrual cycle, really it doesn't warn us. Basically, it's coming on the 10th, and it will come on the 10th, whether you're hungry or not. And it's something that we at Miss Ghana UK Foundation feel that is very important. We all know that is an important part of a woman's life. So we decided to take that upon ourselves. As you already know, we have other initiatives that we support, but this particular year we're trying to concentrate more on the menstrual poverty campaign is one of the main ones that we're working on. So it's important to every female. We know that back home sometimes people struggle, or as you mentioned earlier, deprived areas. So, we want to basically support our younger ones in Ghana and other places, there are other projects that we're doing in the UK that also kind of sticks by this a pound for a pad in the UK. So going back to what I'm saying, we're going to Ghana and we're supporting a lot of schools. We've been doing this for years, and we're supporting a few girls' schools. We're supporting an orphanage. So we need everyone to come on board to come and support us, just like as your good self and BWF is supporting us. We've got a few local community organizations that are also supporting us. We've got Special Lady that deals with a lot of female staff supporting us. We've got Genius Blooming Sense supporting us. We've got a few other organizations that are supporting us. So we need everyone to come on board to help us to be able to support a young woman who is not as what do I say, who's not as, privileged to just go down to Sainsbury's to get a sanitary towel.
All right. Now you're asking us to come dine and support. So we're going to meet over food and drinks. And actually, what will happen? Is it just a networking session, or we need to come well loaded in our pockets to support?
So it's a combination of both. Come in well loaded just so you can support to buy a few young ladies sanitary towels. However, it's a networking event. It's for everybody. You come there. Should I say Ghana Meet Me There? It's a mini version of that. So yes. Come in there with your loaded pocket or card, because these days everything is electronic. We'll have our cards, our electronic device there as well. So yes, and then meet at like-minded people, network with regards to, it could be businesses, other stuff. But we will really love to meet everybody who who wants to support a very good cause that is helping us, our little people, our young women in Ghana.
All right.
So it's a combination of both.
Yeah, so the venue again, if you could retrieve that for us as well, please.
So it's like Gina's Blooming Sense and is in Tottenham and 17.
Okay. And it starts at 7 p.m., I guess.
It does, yes, 7 p.m. Come and let's dine and donate and support other people that need the support.
Well, thank you very much. We will be there. If nobody's coming, at least trust that I will be there to support, Miss Ghana UK Foundation. But I know everybody
Yeah.
live with us, the whole community will come in. Even if we don't come in person, our donations will definitely come through, and we will support you. Is there any number you can put on here for us, so if we need any further information, we can contact you?
So we've got links. We've got the Eventbrite link, and we will put it on BWF. We've got basically information info@missghanauk.co.uk. You can also send emails there, and we will definitely respond straight after. A number that you can contact is 07958 You
That
can
was that was
contact
too that
from
was
that
too
as well.
quick. That was too quick.
Was that too quick? Oh my gosh. Maybe the email will work. Should
Okay.
we use the
Now,
email? I think the email will be the best one. So info at Miss
any
Ghana
means is
UK.
fine. Any means is fine. Well, thank
Okay,
you.
so
Eh,
info at Miss Ghana UK
That's right.
.co.uk will be a perfect one.
That's right. Thank you very much for your time. We appreciate that. We'll be there.
Thank you. Thank you very much,
All
Kweku.
right.
Have a blessed day all.
And you. All right. Miss
Okay.
Sheila, Miss Lajo of the Miss Ghana UK Foundation, helping us there to understand the campaign and also sending us the invite. So I invite everybody to come join us on that day, the 31st of March 2023, North London, 7 p.m. is the time. We'll put the poster on again later on. But let me come back into my discussion. Antobam, thank you for joining us. Aban Wan Smith, Cornelius, you are watching. Adana Shade, thank you very much. Chiwo, not Chiwo, you didn't even listen to anything. You just said she has a nice voice. Anyway, everybody has his or her interest, so that's fine. And Anekia Fosima, thank you very much. And Nanahima Sapong, thanks for the compliment. Lily Soa and Ezekiel Johnson, I have taken note of that. I'll get my AT to support and correct that. Let's keep sharing, family, and let's get into the discussion. Lawyer, sorry, I took the wind out of you, so I'm bringing
Oh,
it
sure.
back. No recourse to public fund. It scares people. What is that?
Thank you very much. So, if we say no recourse, before we get into the nitty-gritties, let's look at the background authorities or the laws that gave birth to this.
Right.
Now, the state takes money from those who work, and we call that tax.
Okay.
That money is put into a pot, and we call it public funds. That public funds is supposed to be used for development and also social intervention.
Right.
Such social intervention includes supporting the needs of people who are destitute, people who have limited income, and people who are going to become destitute. We call them imminent destitution, or that position, imminent destitution. So the question is, if this is public funds, who qualifies to enjoy that?
Okay.
So the law says that anybody under Section 118 of the Nationality, Immigration and Asylum Act, 1999, it will tell you that anybody with limited leave to remain, has no recourse to public fund. Recourse means access. So if you don't have access, then you cannot go near it. So when leave is issued, it has to be made clear whether you are one of those people who may not have access or recourse, or you are exempted.
Okay.
So if there is no condition, then we assume that you are exempted. Because if it's not there, then you can approach it, so to speak. So it has to be made obvious on your card that you do not have recourse to the public funds. We know that the public funds is the taxpayers' money, the money from tax that we use to build the country and also use to help those who are in. and it is for those who can qualify to access. And the law makes it clear that if you have limited leave to remain, you do not qualify, especially if it is clearly stated that you do not have recourse.
Now, if you say that limited leave to remain, people come in and they are given 2.5 years, and they go on that route, some 5-year route, some 10-year route. Does it mean that anybody or everybody that's on that route that's giving 2.5 years does not qualify for public funds? Is that what it is?
So what it is that under section, as I mentioned, 118 of the Immigration Asylum Act 1999, it says that those with limited leave to remain. However, there is an exception. The exception is that if the person has limited leave to remain, but there's no condition attached, then the person can qualify.
Okay. So if you do qualify, it will be
made obvious. Yes,
it will be expressed clearly on your visa, so to speak. If
Yes.
that's how people understand
Yes.
it, that you do not qualify. What makes somebody qualify and others do not? What would be the criteria?
Okay.
Because if I have 2.5 years or limited leave to remain, as it's technically known as, and another person has another limit or the same limited leave to remain, but I may have no recourse on my thing, the other may not. What brings out the distinction?
Okay. So as we said, if the person has no condition attached to his or her leave, even if it is limited leave to remain, then we assume that the person has been given exemption
Okay.
or waived. So oftentimes, if someone makes a fee waiver application at the time of making the immigration leave application, and the waiver is granted, and the person is going further to make the main application, the person will put a request forward to the caseworker or the Secretary of State that I wish for me to be considered to have access to public fund when my leave is granted.
Okay.
For such a person, the leave will be granted with no condition.
Right.
And once there's no condition, it means the person has been exempted from the duty to restrict under section 118. So the state has a duty to restrict those people who have limited leave to remain, provided there's exemption given to that person not to restrict them, then they will be restricted.
Okay.
Now, you can see that we are talking about limited leave to remain. What if the person has unlimited leave to remain? But we don't say unlimited leave to remain.
Indefinitely.
We say indefinite leave to remain or settled status.
Okay.
If the person has indefinite leave to remain, then this is their home. So they
That's
are
right.
part of those who qualify for the public fund.
Okay.
So they are not restricted. So if your card, if you have indefinite leave to remain and there is a restriction or a condition not to access public fund, then it's issued in error. You have to take steps. So
Okay.
that's one part. The other part is those who have become British nationals, either by birth or by operation of law, registration, naturalization, or through whatever means. They have become citizens of Britain, then they have arrived. And once you've arrived, you have no condition.
Okay.
If you have indefinite, you have arrived, no condition. If you have limited leave, you haven't arrived yet. It may be that you change your mind and go back to your country. So you cannot have the right to enjoy what everybody else is enjoying.
In the beginning, you mentioned that if you live in the UK, you work and contribute to the public pot. People who have a limited leave to remain obviously work and they pay taxes and they contribute into the pot.
So I agree. But the difference is this. When they are making the application, they say that I have what it takes to be able to survive. If I'm making an application, limited leave to remain under 5-year route, you say that I meet the maintenance threshold. If you are coming from abroad, whatever application you are making, entry clearance, you say I meet the financial requirement.
Yeah.
Meeting financial requirements means you are okay. So you don't, you're not going to be a burden on the state. That's what we say.
All right.
So having been granted, why should you be a burden on the state if you have expressly said that you are not going to be a burden on the state? That's one argument.
Okay.
And therefore, with those with limited leave to remain, either you have already met the requirement to show financial independence before you are granted. And even if you are on the 10-year route, which is the exceptional situations where you don't meet all the requirements and you are given that concession to be put on the long route, you still say that I do not meet, but I have to be granted. Then you'll be given that condition not to have access. Provided for then that is where the provision comes in. Provided you have made express request as part of your application that you should be considered because you are destitute, you're going to be imminently destitute, or you have limited income. And on that basis, once the application is granted, that condition will be removed automatically for you. And once it's removed on your card, you see that there's no condition there.
So in this situation, the express answer to our question will be that yes, you can have access to public funds or recourse to public funds, but you must meet certain conditions before that bet is removed off your head, and you can then put your hand in the pot.
So the next stage is, how do I become part of the rightful owner, so to speak?
How do I show I have arrived?
How do I show I have arrived? Right. So, and we use I have arrived in specific context.
Right.
Yeah. So, how do I show? So, you are making a request that possibly you could have made at the time of your application, but it didn't possibly occur to you now. So, on hindsight, you realize that you have become destitute, you have become, or you are going to be destitute, or you have limited income, and you are making a request. However, this wasn't the case before. So the default position was strictly under Section 118, where nobody can access if they have condition attached to their leave.
Okay.
Then COVID came, and it became a global issue, so that those who worked were even suffering. What about those who were not working? And the next thing is those who are working but with children and therefore their income is limited. Or a lot of people were also put into that destitute bracket where essential living needs became a challenge for themselves and especially the children. Now the focus is the children involved more than the parent in question. Because when the parent was making the application, they said, yeah, okay, they can survive without public fund.
That's right.
But the children did not say that per se. And the children cannot go to the government to say, I want public fund. Apart from their normal, if they qualify, 20 pounds something a week they get, child benefit bit. But there are other social support, financial support that the state could consider the needs of the children and make a concession. And in this case, the children cannot go to ask for help. That means they will do it through the parent. But the parent is restricted. So how can the parent go forward? That is where the parent will have to make an application for the condition to be removed first
before
to
you
give
can
them
bring in the
access
consideration of
to
the
that.
program.
Because it says no recourse. So you should be able to have recourse to be able to access the public fund. So as I said, the case of R and the Secretary of State, by looking at R, there's a child called W, and this child went to court through a litigation friend, J, and this was supported by what we call Project 17. So Project 17 is a charity organization that supports the welfare of immigrants, and especially those in destitute situations. And during the period of the pandemic, a lot of families were in trouble. Single mothers, non-British children, and also immigrants whose children are British. but they themselves are not British. So look at all these categories, and these are most people who fall under the no recourse category. So when the pandemic hit, the case went to court, and the challenge was to look at Section 55 of the Borders, Citizenship and Immigration Act of 2009, which says that in every decision of the state, we have to consider the paramount interest of the child involved. So if Section 118 of a particular law says that if you have limited leave to remain and you have no recourse, you cannot access the public fund, and there's a child involved who cannot access public fund through their parent, and therefore they are dying or suffering or their growth is stunted, then what we are saying is that the law is causing problems for the children. So that law, that decision to restrict, has not factored in the interest of the children who might be involved. So Section 55 argument is made out. Then we're also looking at Section 149 of the Equality Act 2010, which says that in every decision we have to ensure that we do not engage the protected characteristics, including race, sexuality, sex, maternity, and all those. Now, what we are saying here is if a law is made to restrict people from accessing public fund, and those people can be categorized into certain shapes or forms, then we can engage aspect of the Equality Act to say it appears that there is direct discrimination of certain people who have limited leave to remain, and these people are potentially immigrants of certain racial background, or these people may be single mothers, or these people may be, even the children themselves are discriminated, because if your parent cannot access to be able to take care of you, then you are discriminated against, just because you are a British child. However, your parent happen to have limited leave to remain and cannot access public funds.
Right. So the rights of children, the interest of children, play a very significant role in whether that condition will be lifted off anybody's head. Do we just look at children literally, or we may look at certain conditions in their life? For instance, being able to have 3 square meals, being supported properly, proper accommodation, social needs, and the rest of it. Are these things we consider? Or naturally, if somebody has an income of X and he has 3 children, then it means that if the public doesn't support, the person cannot take care of the 3 children, depending on the person's income. Is that a bit of a natural thing like that?
So to enter into that conversation further, we are looking at what the learned judges said in this particular case. And this is a case of 2020, pandemic case.
Okay.
And that is the beginning of removal of conditions, no recourse. And since then, there have been lot of people who have taken advantage and they've been successful.
Okay.
What the judges said, Lord Justice Bain and Justice Chamberlain, what they said is that it appears that the law has not considered the needs of children who may be involved.
Okay.
And it appears that the law, as exists, has put a blanket approach to dealing with everybody, regardless of their peculiar circumstance. And also said that it also appears that the law has ignored the tenet of the Equality Act, not to bring about discrimination of anybody. So all these arguments came to the fore, and they concluded that if this is the policy restricting people from accessing public fund, and that is affecting the needs, well-being and welfare of the children, then it's a matter of safeguarding and child protection, and therefore it is not in conformity with public good. Okay. So it has to be changed. So the Home Office had to revise its policy and say that if you qualify, knock on the door and we'll check and open.
How do I know I qualify?
Right. So the first case, remember we mentioned Section 55,
Yes.
and it's a well-being of children or interest of the children. So the first factor is there a child involved?
Yes.
So you have to make sure that before you go, you are going because of your child.
Would it be a tick box exercise?
Well, tick box, but there's also a case of meeting the threshold of the law.
Okay.
So if that is what you mean by tick box, and I'll say yes, some level of tick box.
Yeah, because
so the first one,
the
yes.
first one is there a child involved? I say
Yes.
yes.
So you have your child whose needs are affected because of your situation. Number two, before now, what was your situation? Financial situation.
Yeah.
So if you are knocking on the door now,
I had something I could depend on as an individual.
Exactly.
Now I have two children and I'm earning the same wage. So
you can see that before your means was enough to meet your ends. But now things have changed. Your circumstances have changed, but your financial situation hasn't changed, and therefore, either you are going to be imminently destitute, or you have limited income. It's always a case of limited income. Most people may not be destitute, so you check: are you a destitute person or destitute family? Or imminent destitution. Therefore, in the next 12 months, will your financial situation change to the point where your needs will not be met, especially that of the children involved?
Okay.
And the third one, do you have limited income? So it's often the case that somebody may not be a destitute, somebody may not going to be destitute, but they have limited income. So three thresholds: destitute, imminent destitute, limited income. Any of them suffices. Sometimes
Do
you
I
can
have to
even
satisfy all three?
any of them suffices. So
Okay.
one of them. Some people may even have all of them, but one of them suffices. Then we're looking at, okay, so if you claim you have limited income,
Right.
is it not a duty on you to prove it?
Yeah, obviously.
Good. So then you have to look at the duty argument to prove that indeed your claim is valid. Are you a destitute person? What is a destitute person? A destitute person is someone who is not able to meet essential living needs: food, clothing, shelter. So are you sleeping rough? Are you sofa surfing, living in somebody's living rooms and kitchens and stuff? Are you all over the place, moving from one place to the other at the mercy of benevolent people, and so on and so forth? Then you appear to be a destitute person. Are you going to be imminently destitute? Therefore, your income is now, and over the next 12 months, things may change. There is a case I'm handling where the person had one child, was earning X amount, and appeared to be okay. The person now has a second child. The person is now, because of childcare duties, gone part-time. The income I worked at was about 920 something, 28 pounds. The person's rent is about 1,050 pounds. So you can see that now that the person has gone part-time, the income is not even enough to cover the rent. But before, it was enough to cover the rent and themselves, one child, herself and the child.
Okay.
Things have changed, yes. So is this person going to be imminently destitute? Potentially, yes. But over the next 12 months, things are going to be precarious.
Yeah.
So you do all
In
these
this day and age where energy prices and everything are
Exactly.
going up, yeah.
And
Inflation is
exactly.
hitting us right in the face.
So here the person will have to make an argument that this is what I'm going through, and it's also a case of evidence. So I requested all the things I need to show that her financial circumstances are as she claims to be. So what do you have to bring? All bank statements. All bank statements.
Over
Yourself,
a certain period.
yourself and your children. Yourself, so all household bank statements. Don't say that, oh, I'm the one doing it, so I bring my bank statement. It doesn't send my children. No.
But if the children don't have bank statement, what do they do?
So the question, all, how many do you have? So the question I always ask is, how many bank accounts do you have as a family? If there's husband involved, all of you. If there's no partner or husband, you and your children. So I usually ask, do you have savings account? Do you have current account? Do you have any other bank account? There's one case, I was doing the application, the person gave, then when you finish the application, to ask you, do you have another account? So anytime I finish with one, do you have another one? Think about it. Think about it. Do you have savings? Do you have this yourself and the children? Oh yeah, the other one. Okay, bring it.
Bring it.
Oh, the other one, bring it. So a lot, all of them. It doesn't really matter whether there is money in it or no money in it, provided the account is not closed.
Okay.
If the account is not closed, then it is active. So you have to disclose it. If it is closed, then we assume that it is not necessary to disclose. Because when they go to check, there will be nothing to see, but the account is closed. But if the account is not closed, then you have to disclose it, yourself and that of the children. If there's a partner involved, the partner as well. So you bring everything, savings, current account. It doesn't matter how many accounts, bring everything. Then the assessment will be made on each account. How much is in the account? So let's assume that this person has limited monthly income,
Okay.
but has unlimited, and I put this in quote or inverted commas, unlimited savings.
Okay.
Can we say that this saving is not for, it's for something else? So they should only consider the monthly income? No, household income, including savings.
So even if there is the plan to save towards the young person's university education, for instance, could we put a name to it, say that should not be included in the calculation?
All right. So what you are telling me is that you have money ring fenced for future use,
Yes.
and you are willing to die today before future.
Yeah.
If somebody doesn't intervene,
Safeguarding my children's
oh,
future.
but I mean, this is a common sense test. You have something sitting down, but you are willing to go hungry. It doesn't make sense.
Right.
So that pot of money sitting somewhere, for it to be considered in this assessment, we have to show that it is already used up.
Okay.
It has to be used up. If I say has to be used up, what do I mean? All I'm saying is that you have to show that there's no savings to be able to, for somebody to say that you have it somewhere and therefore you should be able to survive without recourse to public fund. So if you have savings, then that can affect the assessment and may not go in your favor. The question, how much savings? How much savings depends on your income, your need, your outgoings, as against the pot of savings sitting somewhere. So let's assume that your outgoing is, total outgoing is £2,000 for simplicity, covering yourself, children, food, shelter, clothing, grooming, telephone, everything.
Okay.
For the month, it's let's say £2,000. You have savings of £10,000 as a family, whether it's for the children or for yourself, it's for the family. So let's look at how long it will take you to meet your needs, considering that you have £10,000. So in terms of the cycle, it's about 5 times, so 5 months. So at least you can argue. So here, at the moment, you have limited income.
Yeah, it could be used up in 5 months.
Used up in 5 months. So the argument will be that, all right, so then you have to stretch the argument to cover the fact that, yes, this is it. And therefore, the calculation, even though I have this pot of saving, it can only last for 5 months. And after that 5 months, things will change. And therefore, we're likely to become immediately what? Destitute.
And you meet the condition.
Then, so you are moving, because you have to prove your case.
That's
and it's a matter of you saying that.
No, then it means that for me to prove that that condition should be taken off my resident permit, I would have to, one, be strategic, truthful, and be able to provide evidence.
So if you are being truthful, then you are covering the other two.
That's right.
Fine, strategic, you cannot circumvent truth and evidence by being overly and selfishly strategic. Because if you are going to be strategic selfishly, then truth will make you out.
I don't.
Anyway,
Yeah.
So the point is that, yes, you have to be truthful and you have to show everything. Because even if you don't tell them, they will fish it out. So when people come to me for this, I ask them, and this is similar to fee waiver. I ask them, okay, you said you have 2 bank accounts. Are you sure it's 2? They will find out anyway. So you better tell them now. Then think, and oh, there's one somewhere. That's okay. What about the children? They have it or they don't have it. And somebody will say, oh, this is for the child. But mind you, it is in your name.
Yeah.
Most of the time, it's in the parent's name.
The parent's name.
So it's the account for the parent or for the child. It's only in name.
Anyway.
But in reality, it's for the owner. Isn't it?
Yes, I can.
But even if it is for the child, we are fighting this case
on behalf of
the child under Section 55.
That's right.
The best interest of the child. So if the child whom we are trying to make a case for has money sitting somewhere, then it appears we are fighting a losing battle. So we have to consider that. So we put all this together, we make a clear assessment, we do budget analysis, income and expenditure, and look at whether there's surplus or there's deficit. And if there's surplus, how long can this surplus last the family in terms of meeting needs? If it's going to be available to cover their needs for, let's say, short period, then we can't say this surplus is enough, actually. Because if the surplus is like £100, that's not significant enough. But if the surplus is, let's say, £5,000, £2,000, surplus means you've covered everything and yet you have something left.
Yeah.
So if you've covered everything, you have something left, would they really listen to you per se? Maybe no. Because you are not destitute and you are not going to be, unless then you argue that things will change and therefore you're going to be imminently destitute within the next 12 months.
Okay.
Now, one other thing that we have to be mindful of to be able to get it removed is explaining every detail on the bank statement.
Okay.
So you bring the bank statement full of transactions in and out. So all the money coming in, you have to make a case for. Where is it coming from? Why wouldn't that continue?
Okay.
What if it is coming from different quarters and it's going to continue from different quarters? Then you are not bad after all. It could be friends and family. And the money going out, why is it going all the time? Does it mean you are better off and helping people? Then why are you coming to seek help?
But then, anyway, you need to justify that. If it's for the needs of the young person involved,
So,
school trade, various activities, buying their needs here and there, then obviously you have a case to prove.
yes, so you have to ensure that those ones fall within the what we call essential living expenses of yourself and the children. But there are instances where people also have family, especially parents, and it's our duty to take care of our parents, regardless of how much income we have. We have to bear them in mind and therefore remit for the needs of our parents. So if for whatever reason your savings is used up or going to be used up for the medical treatment of your parent or your mother, father who is in critical condition, then there should be evidence showing the cost. Then we can map it to the savings to say that even though there's this money currently here, this is the bill that I have to meet for the treatment of my mother or father who is unwell, and therefore there isn't really
should that person be within the UK or could be any?
It doesn't matter where. Yes, so that one. So here we want to see where is the money going to. So we should be able to explain. So there are instances where people get funds from family and friends. Why do they give you money? Is it that you borrow from them with a view to pay back? And why do you borrow? Is it because of your limited income? So if you don't borrow money, you cannot survive and meet that needs of your children. Then you can see there's a serious issue here. So the person is living on loans, or the person is only living on support of other people. If you are living on support of other people, then what shows that they cannot continue to support you?
For instance, if somebody has a credit card or two uh, and it's almost used up within the period that the application is being made. Would that be considered that the person is living on so much credit because there's no sufficient income?
So that's a good point to include in the argument. So when I ask people to demonstrate, I ask for everything. I ask them, do you have a bill,
Letter.
letters and stuff? Do you have penalties and other things you haven't paid? Do you have debit?
Credit card.
Do you have standing orders and direct debit arrangement? Do you have loans that you are still paying? We're not talking about personal loans that you are still paying. You have store cards that has built up. You put all this together and check, calculate. So you can see that in addition to the essential living expenses, there's also commitment that ought to be met.
Catered for. Right.
So once we add the commitment to the normal expenses, we even see that the expense budget is even higher than we thought. Then we match against what a person has as income. Rather, there isn't really much. And our next question would be, where are the fathers? It's mostly the fathers who may not be available in the lives of the children. I said it's mostly, and I'm using it carefully. I'm not saying that it cannot be the other way around, but it's always the case that observations show that this is the trend. Now, so the question is, if the child is living with the mother, where is the father? How much is the father contributing? Is there any child maintenance arrangement set up with a child maintenance service? How much? Is the child receiving public fund through the other parent? How much? So we put all this together into the income pot for us to ascertain the income level that we match against, knowing that there's no other money elsewhere, that we can conclude that comparing the income against the expense, this family is distressed.
Well, obviously, we are getting answers to the question, how do I qualify for that condition to be taken off me so I can have recourse to public funds? Lawyer Charles has been gracious and very detailed, very systematic, strategically put everything in there for you to really understand. But what I would advise is this. Listen, if you have a need and you need to get this taken off you, speak to a lawyer. You see the strategies he's been talking about, the questions that he says, I ask my client, I ask for this, I ask for that. It may not occur to you, but to them, especially BWF solicitors, they know, they have the experience, they have the strategies and I wouldn't say tricks, but there's no trick in there. They have the right strategies to go about it. So speak to BWF solicitors. They are 214 to 218 Tottenham Road, or Seven Sisters, North London, N154 and Q. Call them Monday to Friday between 9:30 and 6 p.m. 0208-493-7340 or 077-127-61884. Adana Shea, thank you for joining us. Sally, you're here. Thank you. Element Cleaning Ovens and Carpet Specialist. That's a good source of advertisement there. Thank you also for joining us. Lucas Adom, Vera Kiaminta, I see you. Kate Muzu, Frimpoma Tutua, Mami Oda, Francis Pokufufie, Sandra Fraser is still watching and distributing as well. Ajiwan and Ajimai, thank you. Kevin, how are you? I know you're doing so very well. You say good afternoon, Riku, and lawyer Sir Charles Asma. We have Delali Gomado. Now, Sandra is giving the details. Yes, as she does usually, telephone numbers of all the lawyers and the front desk one and the emergency one as well, 077-127-61884. Now, let's quickly take a few of the comments on there. If you have any question you want to put to lawyer, this is the time. The number to call is 07399208468 or 077 No, 07950422780. That's for our our text number. So I take the number again: 07399 or 0208 123 1016. You want to text, send a WhatsApp voice note or anything, bring it down to 07950422780. A few of the comments there from Facebook, from YouTube, and from our platforms. Delali Gumado, you're watching. Yabachiajima, you're watching. Thank you very much. Julie D. Ansu, also thank you for watching. Now let's pick some of the comments from on board. Applicants who are granted leave outside the immigration rules automatically get recourse to public funds. Is that a statement somebody is saying?
Well, yeah, so that's the point the person is making, that if you are given exemption from the condition, then you qualify. So you can see that the person is that if you are granted outside the rules, but if sometimes you can be granted outside the rules on the 10-year rule, but not necessarily waived in terms of condition being removed.
Yeah.
So there are exceptions to that point being made here. Now, in that, somebody will go through that channel, but with a fee waiver.
Okay.
If you are going for a fee waiver to make your application, then what you are saying is that you are destitute. Because fee waiver, you have to prove destitution, imminent destitution, or limited income to meet that test. So if the government agrees that you cannot pay and therefore waives it for you, then why would they restrict you from accessing public fund, knowing that even your fee you couldn't pay? It becomes a common sense approach the government will take to say that on that occasion, this person should be exempted.
Okay.
Automatically, supposedly exempted. But it doesn't mean that all those with limited leave to remain 2.5 who are under the 10-year rule will be exempted. Because if the person can pay for it, would the person be exempted? No. So I agree in part with Jonathan.
Okay. Well, now, there's another one. Let's pick that one quickly. You can call in 0208 0208 Text or WhatsApp 07950 You can put your comment or your question on the platform and will be picked up for lawyer to help address that. Lawyer, when no recourse to public funds is lifted off anybody's bid, does it vary the number of years that's granted on the permit?
No, I mean, we know that no recourse is just to say that you can or you cannot access public fund.
Right.
So if you are given 2.5, be it whatever the route is, and you qualify for the condition to be automatically removed or removed at source, then they will remove.
Okay.
So you have your leave with no condition attached that you can access. So somebody, for example, who makes an application for SEDI, but remember, SEDI automatically takes you to indefinite leave. And if you have indefinite leave,
Well,
you don't have the
for
condition.
purposes of friends who may not know, said DV as for domestic violence
Yes.
application. Okay.
So if somebody makes application based on domestic violence situations and they are seeking government intervention to protect their life, then the person will be escalated to the settled indefinite leave to remain will be granted. So if you are given indefinite leave to remain,
Then you have,
automatically there will be no condition anymore.
then we go to
I have
adapted term.
arrived.
You have
Very
arrived.
sort
Okay.
of. But this person with limited leave to remain, and so again, back to Jonathan's position or point that exceptional situations automatically granted a recourse, but not all exceptional situations. Because if you are making an application at a 10-year route, as we said, it's an exceptional situation because you don't meet the requirements. Either you don't meet the maintenance, or you don't meet something, then you are put under the 10-year route for 2.5. If you are doing it based on long residence, 20 years, long stay in the UK, you don't meet the rules, but you've been given a concession to get 2.5 on that provision. And these people, some people are able to pay, some are not. So those people who are not able to pay, they go for fee waiver. When, for example, we are making the application, we make a case to the home office as part of the application that this person is already destitute. As a result, you have given him or her a waiver, so they don't have to pay the fees under Section 3 of the HRA. Therefore, we request that, or we plead that when the decision is being made to grant the 2.5, they should consider removing the no recourse or not attaching
Attach.
condition.
Okay.
So in this case, the person will have the leave with no recourse.
Oh, okay.
But why did the person have the leave without no recourse? Because the request was made as part of the
As part
application.
of the application. Okay. We'll be going over to Namati in her beautiful corner. She has a few of the questions that were left over. Let me recognize Delali Gomado. Thank you for joining us. Yawachi Ajimai. Hope Lando Connolly, you watching. Thank you very much. Good evening, everyone. Ajiwa Nanajimai, thank you as well. So, Ezekiel Johnson, can we get now on and we address Ezekiel's concern? Ezekiel is asking that I think it says there's a confusion as to what time your show starts tomorrow. Is it 2 o'clock BST or 4 o'clock BST?
Oh, it's 2 o'clock normal time. In the UK it's 2 o'clock, but because the time is changing, so it's going to be 1 o'clock in Ghana, but 2 o'clock in the UK as usual.
Okay. Well, Ezekiel, I told you I was going to get that answered for you, so that's what Anan Mayeti has done now. Now, I know during the week, between Thursday and Friday, there were questions that may have overlapped. So let's come to your corner and see if you have any that will bring Lawyer Charles on to help answer them.
Yes, thank you, Riku. I've got one major question that about three people asking me this particular question. And the question is, if someone in the UK already with a student visa, and then the person switches to the skilled migrant route, this person, if this person is to marry someone from Ghana to come, is this person going to meet the 18,600 requirement, or is just the money that the company will be paying, would that be enough to meet that requirement? Secondly, if the person hasn't married this person already but now going to marry the person, would the requirement be the same as being married already and you are coming together, that they'll be only looking at the marriage certificate, the police clearance, and the TB test from the spouse? Is it going to be only that, or there will be any other requirement with it?
Right. Thank you very much. First off, there's no difference between when you married and when they are coming. They are coming as dependent, and that is the starting point. The next point is to meet the requirement for entry clearance for dependent of a skilled worker migrant.
Mm.
To prove that you are a dependent, you have to show that there is familiar relationship in terms of marriage or in terms of child-parent relationship. So if it is the spouse, you show that you are married to the person, so marriage certificate. And it doesn't really matter when you married. This is not EU provision where date of marriage is paramount. This
As,
is under Appendix FM, skilled worker, Appendix skilled worker, and therefore the provisions are clear. If you're a dependent under Appendix skilled worker, you have to show that you are married to the person. You are married to the person, not you are married to the person at this time. You are married to the person at the time you are making the application as a dependent. You should be married to the person. So marriage should have taken place before you apply as a dependent. Then the next stage is you have to show maintenance. Now, most employers will make provision for the main sponsor, the sponsored person, and
okay.
also their spouse. if they are coming with their spouse or they will be coming with their spouse. So the COS sometimes will make provision for that. If the COS makes provision for that, then the employer has guaranteed that you are covered and your spouse is also covered in terms of maintenance. In that case, you, the dependent, can choose not to provide the maintenance evidence.
Evidence.
However, I will propose, not
Mm-hmm.
advise per se, I will propose that
Mm-hmm.
if you can, just show the maintenance
Okay.
so that, I mean, whether the employer has covered for you or not, you can also prove it. So
Okay.
that is what I will propose to potential dependent, skilled worker dependent. So what we are saying to our friend is that it doesn't matter when they're married. And in
Okay.
terms of maintenance, it's always the case. If they are not covered by the employer, then the dependent must show that they have the maintenance. And the maintenance, the money should be in the account, as you
Mm.
know, 28 days.
Yeah.
28 clear days, clear days. Clear days
Yeah.
means every day counts, 28 days before your application is made.
That's fine. Okay, thank you, Lawyer Asma. I've got another question. What's the time? Yes, Oregu, can I go on? I've got some few
Yes,
questions.
please go ahead. Yeah.
Okay. So my next question is the same, based on the same as the first one I said. This guy is also a student, and he's switching to a skilled migrant route now. He came with a dependent, but there is an issue between these two people, and he wants to switch to a skilled migrant route. Does he skilled when he get the skilled migrant route, does it automatically covers the dependent, or the dependent also has to apply for? So if, for instance, they having an issue and they decide to go and divorce, or decide to say probably say no, because we are having an issue, I'm going to get a skilled migrant through, but I don't want you to come and depend on me again. Is there any possibility that can happen? The first one, is it automatic? And then the second one, is it possibility that this can happen without any consequences?
Everything is possible in life, you see. So possibilities are everywhere. Never
Okay.
underestimate possibilities. But the point is this: you come in as a skilled worker migrant with your dependent spouse,
Okay. With the
whether you
he
came together or they joined you later, because they
no, no,
switched.
as a student, yes.
Okay, so came as a student, but is there a student dependent here?
Yes, both of them are here.
And they are switching.
Yes.
So if the main person is, let's assume that there's no issue. If the main
Okay.
person is switching, they
Mm-hmm.
go along. The dependent tags him or herself along the main person, and they make the application together. Main
Okay.
person, dependent also
And
makes the application.
mm,
So there will be two applications, one and the other.
okay.
Then you are saying that what if there are issues?
Yes.
Issues come, issues are resolved. But if they
Okay.
are not able to resolve their issue and the marriage is dissolved,
Mm-hmm.
then the dependent, see the link. What linked the dependent to the main person is the relationship.
That's correct.
So if the relationship is severed,
Mm-hmm.
what else is there to use?
Okay.
Yeah, so it's like the salt episode. Salt is good, but if salt loses its
Taste.
taste, what good will salt be?
B.
So if this person has lost the relationship, then
Okay.
what good will you be to this person?
Mm.
So when they are going, they go alone because you can't say they are with you and they can't
And
say they are for you, so to
yes.
speak.
Okay.
So what I would say is that if there are issues, they should resolve the issues. However, if they can't resolve the issues, then the dependent can also look for a sponsor to move
Mm.
onto the skilled worker route as well, so
Okay.
that they go their separate ways as independent migrants.
Okay, Lawyerman, let me extend this a bit. This person is actually filling a form to apply for the skilled migrant visa, and there is this portion that he needs to write the names of the dependents on the form. And because of this issue, he doesn't want to write the names of the dependents. So if he refuses to write these names on the forms, is there going to be that automatic thing? That's where he's a bit confused, that if he doesn't write the names on his form, due to the fact that previously, before they were coming from Ghana, they had the forms together, they have everything together. But now that he is switching and he's filling a new form, the side where he needs to put the dependent details, he's refusing to do that. So is there going to be that automatic thing? That is where the question
So
is.
automatic thing for who? For the dependent or for the main person?
No, for the dependent.
So the main person who doesn't want to help is thinking about the dependent.
Yes, that
But you
would
don't
there
want to help. Why are you thinking about the person?
no. Maybe you didn't get me. He's saying, would there be an issue? So if he doesn't,
Issue for who?
for the dependent, if he doesn't add the name, what happens to the dependent? That's what he's asking.
I understand. And I mean, I only brought in that if you have chosen not to help, why are you so concerned about what happens to the person? That is the point. But anyway, so the situation is this. They made the application. So this person is making the application. They have a dependent. Ideally, they will include their dependent.
Yes.
If they don't include the dependent, for whatever reason, let's assume that they forgot to include the details of the dependent and they
Okay.
submitted the application. The application likely to be granted, but when the dependent is making their application, they are making application based on the main person's application.
Exactly.
So the question is, if the main person has not represented that they have dependents and included their details,
Yes.
there might be conflict when they
Exactly.
pick the dependent's information up to process and they want to link it to the main person because the details will be there. And the
Yes.
question is, if you are the dependent, how come your partner, the person you depend upon,
Yes.
forget or did not remember to include your details?
Exactly.
That is the bit. And that is what the person knows that it can happen. And that's why I'm
Okay.
saying that if they know that this can happen, then they should carry them along and help them.
Okay. Anyway. Right. Okay. So there is another one here. Oh my god, I wrote more than 10 questions, but let's see. Let me, if I read this one. My girlfriend, sorry, my friends married to EU citizens since August 2021. The marriage has about 2.5 left years now. I don't know. Can I divorce my husband and or should I wait till we are 3 years through before I divorce my husband? That's the question.
Well, I suppose the person already, so the husband is already in the UK.
Yes, they are here.
Well, if they're already here. But I suppose they came under Appendix FM because you said they married in 2021.
Yes.
And in
Since August
2021,
2021.
yes, 2021 is when they became family members.
That's
And
correct.
under Appendix EU provision, they should have become family members in 2020, before 31st December or by 31st December 2020. So it's likely that the person made application under Appendix FM
Okay.
because the marriage was after the deadline.
Deadline. Oh,
Now, that's the first bit. Second point, which is the main question, is can I divorce after 2.5 years?
yeah.
Right. I mean, if there is separation already, and therefore the marriage is already weak.
Mm,
And if the marriage is already weak, depending on what is happening, sometimes you have to safeguard life.
yes.
And if you have to safeguard life, I don't think you have to just stay on till whenever. So if
Okay.
the need to protect life, then it's better to go through the process.
Mm,
However, you see, we are not talking about application under EU. So
yes.
ask them under what provision was the application made. If the
Mm,
application was made under Appendix EU, then
mhm.
after divorce, this person or the partner who is in quote unquote distressful situation will rely on retention of right application or a provision to
Okay.
continue,
Okay.
because their right would have been retained post
Mm.
divorce because of the intervening factor of divorce. But if the application is under Appendix FM because they became family members in 2021,
Man.
then there's no retention of right under Appendix FM.
Okay.
So those are the
Okay.
technicalities that need to be looked into carefully. So if
Okay.
this person would want to have a conversation further, I suppose they need advice.
Hmm. Right. So, real cool. Just last quick one, based on the previous one that we, this person, they've given her the skilled worker route visa, and she's here, but she's now going to marry. So she's asking, the same process that I asked, which of course I think your explanation earlier on could also answer her. But if there is anything different, you can let me know. Then that will be my last question.
There's no difference.
There's no difference. Okay. All right. Thank you very much, Alaya Asma.
Welcome.
Yeah.
And well, with that being her last question, I would want to also announce that between 2 p.m. and 5 p.m. British Summer Time, Namayeti will be live on radio, BW Radio, and on her Facebook page. Namayeti show will be on between 2 and 5 p.m. I think is that confusion that Ezekiel brought up on there will be corrected, but it's between 2 p.m. and 5 p.m. British Summer Time, which will be 1 p.m. and 4 p.m. GMT. Now, on the 10th of April 2023, ICGC King's Temple is collaborating with BWF solicitors to bring you Easter illegal clinic, and outreach barbecue, Easter legal clinic and outreach barbecue. And it's happening from 12 noon on Monday, the 10th of April, 2023 at the ICGC Temple, Frederick Bremer School, Sidley Road, Walthamstow, London E17 4EY. If you have any further details you want to find out and have, call the emergency number of BWF Solicitor 077-127-61884, 077-127-61884. Then on the 31st of March 2023, we are joining the Ms. Ghana UK Foundation, the program they call Dine and Donate, a meetup for the Pound for a Pad campaign. And they're asking us to connect over food and drinks to learn more about the Pound for a Pad campaign. There will be opportunities to network with like-minded individuals and donate to the good cause they are following. It's the Friday, the 31st of March, 7 p.m. Blooming Scent Cafe, 639 High Road, London N17, 8AA. This one is supported by BWTV and BWF solicitors. It brings us to the time where we will have to delve into our quiz segment. But before we go, let me read the nugget again. That will give you an insight and a context into the question I am going to bring. Ladies and gentlemen, are you ready? Inheritance. Provision for Family Independence Act of 1975 gives power to the court in certain circumstances to vary the terms of a will if it fails to make reasonable financial provision for a surviving spouse, a child, or someone who's been maintained by the deceased during their life. A claimant will be expected at the very early stage to provide full disclosure as to their own financial needs and resources. A person is classified as being maintained by the deceased if they were financially supported by the deceased in some way during their lifetime and that the maintenance continued until the death. This is from the Inheritance and its Provision for Family Independence Act of 1975. And based on a Kate Elot versus the Blue Cross and others of 2017, this case was decided by the UK Supreme Court in 2017. So having said that, ladies and gentlemen, now my question, Rusab, your question came a bit late, so I'm going to my question. Yeah, Browa left all her estate of 500,000 pounds to charity in her last will, although she had a disabled daughter, Abrifa, and they have been estranged for 20 years. Abrifa applied for part of the estate, arguing that the will should have made provision for her. Abrifa was on benefits and living in supported housing. Very, very difficult situation. And that's why I've closed my eyes. Yambrowa had a lot of money, the estate of £500,000, £500,000. In a will, left it to a charity. Although she had a disabled daughter, Brifa, and were estranged for 20 years. So does it mean that of all the 20 years you were not taking care of the disabled daughter? Now, when the will opened, read, waiting for execution, Abifa applied for part of the estate, part of the £500,000, and the argument was that the will should have made provision for her, the disabled daughter of Yambroa, even though they were estranged for 20 years. Now, this person who has made this application, Abifa, was on benefits and living in supported housing. Now, the question is this: what will be the likely outcome of Abifa's claim? One, it will be dismissed because the will did not make provisions for her. Two, she is likely to receive a small amount of the estate, a small amount, small like this. Now, three, she will get the most of the estate because the charities are not family members. So let's see what your answers are. I am having a little difficulty here because now this person, even though made a will, gave it to a charity. I'm not saying the charity doesn't deserve it, but this person had a biological child and forgot about that. Listen, let's do our wills. Let's cater for those we need to cater for and do the right will and the needful. So what will be the likely outcome of Abrifa's claim? It will be dismissed because the will did not make provisions for her. She's likely to receive a small amount of money or of the estate, which is worth £500,000. She will get most of the estate because the charities are not family members. What is your answer? Now, as I wait for you to bring the answer, I think there's a comment that we can quickly pick up on the platform. Let's read this. A visit application was made and unfortunately ticked no instead of yes to a question of have you been refused a visa to the UK before? The visa was being refused on the basis of non-disclosure of information and 10-year ban was put on the applicant. Is the ban restricted to visit application or any other application? I think we'll have a quick answer to that.
So the ban falls under paragraph 9 of the rules. So 9.7.1.7.2, you take then, so that is if there has been false representation.
Okay.
So if they ask you, have you been refused before? And for whatever reason you said no, but the answer is yes, then it appears that you have misrepresented the information as if it's going to make a difference. That's one bit. Or you provided supporting evidence and the evidence were false, then that will also go against you. Once you are refused, they will mention that because of this, it triggers the next level, which will be paragraph 9.8. We say that if you are refused today because of this, any further application will automatically be refused. So if you come again tomorrow to make with your application, it will be automatically refused and the refusal will be under 9.8. The first one will be under 9.7, fresh. Later will be 9.8, but they will make a reference to the one they refused with restriction, never to come again for 10 years. Our friend is asking, is it limited to visit application? Any application that has been made with false information included or with misrepresentations with a view to obtain a grant or take advantage of that. So that is the position the law. So any application at all, it doesn't matter which application.
Okay. All right. Which answers do we have? Elements cleaning oven carpet solutions. I think is one. You think so? Well, interestingly. Let's see who else we have. We don't have anybody, but we're running out of time. So I'll go to lawyer and we get a deep dive into what the answer would be. One here says the answer is one since the will did not mention Abrifa. Kevin and someone says so. Like,
Thank you very much. So we see somebody who has died with a will.
Mhm.
So has died testate, but the will did not mention the spouse, the children, or somebody who was being maintained by the deceased from the nugget under the inheritance law that we referred to in 1975. So 3 people are there: spouse, children, and somebody else. So let's look at the fact. Who are we dealing with? It's Abrifa, isn't it? It's Abrifa's spouse, child, or someone else. The man was helping, or Yambrowa was helping.
Yambrowa says although she had a disabled
So
daughter.
Abrifa is a child.
Yeah.
So Abrifa is a child who was not considered in the will.
Right.
So Abrifa is not a spouse. Abrifa is not someone else. Abrifa is a child of the deceased. But the will did not cover this child's needs. This child has needs. True.
Yeah.
And because of that, this person is even going to the state for support, maintenance support. And without that, she cannot survive, or she will struggle to survive. Can the court make an exception to their will? Yes. The law says the court has the power to vary the will.
Okay.
The will that did not include Abrifa will be varied by the court through its powers under the law to include Abrifa's needs, but not to the point to disadvantage the will beneficiary itself, the charities. And therefore, what she gets will be enough to cater for her needs.
Okay. Before we go on, let me go back to the nugget. There's a part there that I want to base my question on, and it says that a person is classified as being maintained by the deceased if they were financially supported by the deceased in some way during their lifetime, and that maintenance continued until the death. This person, Abrifa, and the mother were estranged, and this Abrifa was living in supported housing. Okay, so prior to the death, this mother was not catering for the daughter.
So this part of the law makes reference to the third category of such exceptional beneficiaries.
Okay.
Where there's no will, there are 3 exceptional beneficiaries
Okay.
whom the court can rely on its power to support them. 1, the spouse who was not included in the will, the surviving spouse who is not included in the will. We don't have a surviving spouse, do we? No. 2, children or child who was not included in the will. Do we have a child? Yes, Abrifa. 3, someone else maintained by the dead person. And maintain means they were helping them, and therefore the help is expected to continue. The third category. We don't have anybody who the man was maintaining, the lady was maintaining. Mroa was maintaining. And therefore the third doesn't come in, the first doesn't come in, the second category, a child. And there's no caveat to that one. There's no caveat to the child, there's no caveat to the spouse. The caveat applies to the third category where it is somebody else being maintained. Then we have to see whether there's maintenance for that person in the first place.
Okay.
So because Abrifa is a child, we don't consider whether there was maintenance for her or not. Her needs ought to be considered by the court to vary the will to meet her needs in that exceptional circumstance, so the court has, in some circumstances, and this is one of the circumstances, and because it's for her needs, it's not going to be too much to make her overly excited, just enough to make her survive.
Okay. So now, I guess my answer would be number two. She's likely to receive a small amount of the estate. Would you agree?
Yes, based on the explanation that lawyer Asman has given, I'm sure that would be the correct answer. She's likely to receive small amount of the estates, and if the court can also override or bury the will, just as he has explained, then of course they will give her something small.
So, something
Yeah, to
small
meet her needs.
to meet her needs. Okay, so let's review the answer, ladies and gentlemen. And the answer is number two. She is likely to receive a small amount of the estate. Well, as I said, it puts people in, or this one reviews the difficulty that people are facing. Let's say, if you have a child, make sure, even if it's a pound a month, make sure you support the child, because you might put them in a difficult situation and you force the hands of the Lord to come in. If a provision is made, even though you are estranged, it's your child. You labored 9 months to bring forth such a child. It's unfortunate that she has some limitations as to her ability to live fully as an individual. So, to me, you have a duty and a responsibility to take care of the child. Let's learn from there. Um, it's a beauty to be a mother. I know if you would want to have a testament of that, now my auntie will tell you, is a beauty, is a lovely feeling to be a mother. And when you see your children so very well, especially when they are celebrating their birthdays, and you look back and say, oh my gosh, I've been able to raise this young woman, young man to such a level that I'm so proud of. So make your wills, leave a estate to your children, especially, even if they have wronged you. Don't get so estranged, even when you're gone. Make sure you cater for all of them. And the Lord will bless them, bless you, and bless everybody. Well, on that note, I will come to Lawyer for his concluding um, statements. Now we'll do as, and I'll close and bring the curtains down. Lawyer.
Thank you very much, viewers and listeners, for um, being with us through the moment of this conversation. The question was, how do I qualify? That means there's potential to qualify. So yes, you can qualify to get the no recourse to public funds removed so that you can access benefit. Now, how do we do it? It's a legal test. And the test is that you must show that you are struggling to survive and to meet your need and that of the children involved or a child involved, and that is a destitute situation, or in the next 12 months, your financial circumstances will change adversely, and therefore there is likely to be imminent destitution, and so you ought to be factored into that arrangement by the government. And the third one is that you have limited income. Now, because this is a case law and statute test threshold, you have to make sure that you actually are a destitute person, or you're going to be affected because of your limited income, and you are going to be a destitute in the next 12 months. How do you prove it? You have to show that while you have a child, you have a child, and this child depend largely on you, and that your income is not enough to be able to support your need and that of the child. If you're able to prove all this with evidence, it is more than likely that the caseworker will rely on the provisions of the law to grant your request to remove the condition from your card so that you can go to the government for benefit or for support. Now, if you do not meet the threshold, or you're able to prove that you have limited income, or you are going to be imminently destitute, or you are destitute already, then it will be refused. Why will it be refused? Because you have shown through your bank statement that you have more than enough to survive without getting support from the government. And therefore, you have to make sure that you have provided all your bank statements. You have to ensure that you have brought everything together in terms of your expenses and what you owe, and also make sure that you have been truthful, as was earlier mentioned by the host, so that your case will be um, decided, or your claim will be decided favorably. This is what we have discussed. We believe that this has been beneficial to you and to others. So rely on the law and get the best out of what the law offers. Thank you. Have a very good weekend.
Okay, so I'll move on to now, Adam.
Yes, Oreku, thank you. Thank you, viewers and listeners. And just a quick one. You know, Mr. Jonathan Bene, who asked question earlier on, is one of my boss. So, in fact, he has just sent a message to me showing gratitude for sharing the message, sharing the program to him. And according to him, he used to work with Haringey Council, and he has helped a lot of destitute people for their no recourse to public fund be lifted. So he's really, really showing happy for me sharing this program, and then happy this thing is going on in our community. So thank you, Mr. Bennett. Thank you for joining us today. Yes, Oreku, I know our time is far gone. I'm still here. Those of you who want to join Katie consult for your English test, that's B1 for citizenship, for skill worker route, we are still here to support you. That's the only thing I can say. Reku, thank you very much.
And with that, I come to the end of the whole story for today. It's been a pleasant evening. It's been a pleasant, exciting moment with lawyer Charles Asma from BWF Solicitors, and also my colleague Na Mayeti for the support. I have also enjoyed your company, and I want to say thank you very much for sticking and staying with us. On behalf of the production team, Professor Ade, my studio manager and producer, and also to Sheila Ankara and Patmo Dudu for doing all the background work and the admin staff and the promotion, to lawyer Charles Asma for his time and of course his wealth of knowledge, to Uncle Ben, the senior partner of BWF Solicitors, thank you very much. And to Lawyer Richard, also thank you for your support and encouragement. To Auntie Cynthia and all the wonderful staff of BWF Solicitors, straight from the trainee lawyers to the case managers and the front desk management. We want to say thank you very much for your support. We'll be back again same time with another edition. But remember, there are two events that I'm promoting now. The 31st of March, we will be joining and supporting the Miss Ghana UK Foundation for their charity event. Then on the 10th of April, Easter Monday, we're going for our barbecue and legal consultation, free legal consultation at ICGC Temple in Walthamstow. Until then, and until same time next week, I want to say be good and God bless you.
Yeah. Jesus, you're my everything, yeah. My everything is you, Lord. Yeah. Oh, 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 oh. Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough.